Indeed, it's my great honor to be here, to be at this prestigious university to share with you about China's foreign investment law. Actually, it's not the first time that I came to this university, but as a speaker, this is the very first time. You certainly know at this moment we are in a time of uncertainty. So how the law has been adopted for quite a couple of years. So what is the role at this moment? The role of the law at this moment. I think it might be interesting, and it will be as what Professor Zhu has already pointed out. It might be timely to probe into its role in such a moment. This I would like to share with you. Starting with a brief introduction, I will probe into the legislative process of this law. Then I will share with you the main contents of the law. And then I will try to find out the correlations between the law and the business environment in China. And then possibly I will move to the limited role of the law in the context of way of foreign investment exit. You possibly have already observed what is going on in terms of foreign investment withdrawal from China. And lastly, I try to propose certain points, something that we can do in order to improve the legal environment in relation to foreign investment law in such a time uncertainty. And you certainly know why foreign investment law is needed in the country. Foreign investment, first of all, can make significant contribution to the sustainable development of a host country if well done. An appropriate regulatory framework, domestic and international, is supposed to be made to ensure investors' confidence and create an enabling environment for business. Possibly you have already been aware that this legal framework must achieve a balance between the protection and attraction for investment and the government's right to regulate in public interest, in the name of public interest. This law, the Foreign Investment Law of the People's Republic of China, was adopted by the National People's Congress in 2019. And it came into effect on the very first day of 2020. This was meant to be a unified code governing foreign investment. It was at the very start as a unified code governing foreign investment. So we can say this law constitutes the basic law for foreign investment in China. What is basic law? You know, in China, basic law means those laws that are adopted by the National People's Congress and its standing committee. This is a general understanding. So we find this law was adopted not by, let's say, the state council. Actually, it was adopted by NPC, even not by its standing committee. So it's really regarded as a basic law, which is of the similar status of civil code or criminal code, criminal law, something like this. These are what we know basic laws. So that's very interesting phenomenon. We certainly know since 1979, a legal system for foreign investment gradually emerged in the Chinese context, starting from the Chinese Foreign Equity Joint Venture Law in 1979, the Wholly Foreign Owned Enterprise Law in 1986, and the Chinese Foreign Contractor Joint Venture Law in 1988. And coupled with these laws, they were so-called implementing regulations normally adopted by the State Council and ministerial rules, which are certainly adopted by the ministries responsible. So you can find a fragmented the laws and the regulations which form the foreign investment regime as a whole. This foreign investment regime was initially characterized by the so-called industrial guidelines and the catalog, which were in the name of the ministerial rules by the NDRC, that is the National Development Reform Commission, and the Ministry of Commerce. So interestingly enough, the guidelines and the catalog, which serve to be the rules governing the admission of foreign investment, actually were in the form of ministerial rules. In terms of hierarchy, they are not at the same level as laws and administrative regulations. So the investment regime was initially characterized by industrial guidelines, the catalog, and case-by-case screening. Basically means every proposed foreign investment must be subject to screening or examination and approval by the authority, case-by-case screening. In addition to this, incentives provision can be regarded as a feature for foreign investment, for the purpose of promoting foreign investment, particularly at the local level. Local governments are competing for foreign investment in terms of providing incentives in various ways. You basically can find almost every government at the different levels, at various levels, were in such a competition. The catalog, which divided foreign investment into various categories, those that were encouraged, those that were restricted, and those were prohibited. And this certainly served as a criteria for the competent authority to follow when they were screening each investment proposal. Such a system, such a regime was designed to serve the role of industrial policy and to attract wanted investment for the purpose of economic development and preventing unwanted investment from entering this country. So it seems it worked quite well in the Chinese context. So advanced technology and export-oriented foreign investment were encouraged, while environmental friendly and other unwanted foreign investments were either prohibited or restricted. And as we said, authorities at various levels offered foreign investor financial incentives to affect their decision concerning location of foreign investment projects. And this really worked well because China, after just a few years, became the second largest recipient of foreign investment globally, just next to the United States, for quite a couple of years. Just mentioning, in 2018, foreign investment flux into China was something like 135 billion US dollars, not Chinese yuan. 135 billion US dollars. Can you imagine? By the end of 2018, there have been nearly 1 million foreign invested enterprises with accumulated amount of, sorry, that is the US dollar sign, yeah. 2,000 billion US dollars in terms of stock accumulated amount, which accounted basically 10% of global FDI, foreign investment. So I think even though the system possibly had a lot to be improved, but it seemed it worked well in the Chinese context. Of course, you may add other factors, contributing factor to this landscape because of the Chinese market, but particularly potential market, the vast market, as well as the cheaper labor cost. They might be also accountable for the landscape of foreign investment in China. And you certainly know China was the largest manufacturer. Among the 500 industrial products in the world, more than 200 were made in this country with the largest output. Yeah. Largest output. Yeah. But still, we have to say the system left too much to be refined. First of all, you certainly know it might not necessarily up to the standard which have been set forth by, for example, by the WTO agreement concerning trade-related aspects of investment measures. Yeah? And indeed, during China's process towards WTO accession, the country has had amended its foreign investment regime. Particularly, it removed certain measures that were regarded as incompatible with the TRIPS agreement, that is the agreement on trade-related aspects of investment measures. Local content requirements, trade balancing requirements were removed as a result of China's effort to join the World Trade Organization. And it must be mentioned in 2013, during the US-China Strategic Economic Dialogue, China agreed to negotiate a bilateral investment agreement with the US. Don't be surprised. At that time, it seemed the two countries were quite close in terms of economic relations. Yeah. China decided to negotiate the BIT with the US on the basis of pre-establishment national treatment plus a negative list. Please remember, bearing this term in mind, national treatment plus negative list. And this had been advocated by the US for years, since the proposal for BIT negotiation was raised as early as 2007. So at that year, this year, what was that year? That year was the current Chinese leadership came to power. They came to power immediately after so-called 18th Party Congress in 2012. The second year, they decided to negotiate a BIT on such a condition which was set forth by the US. And in the same year, the government set up the China Pilot Free Trade Zone to conduct a stress test. What do you mean by stress test? Stress test certainly means when the Shanghai Free Trade Zone or Pilot Free Trade Zone was to be used as a place where those provisions that might be reached between the US and China might be carried out on a pilot basis in Shanghai, in a small area of Shanghai, which is called FTA. Geographically, it was very small, but the significance, I think, was very big. To conduct a stress test in order to show whether China could stand up to, whether China could be accommodated by the new commitments, possible commitments in the BIT with the US. So at this moment, a negative list of foreign investment admission and a registration recording system were announced for the Shanghai Free Trade Zone. So in this regard, I think I need to explain a little bit about negative list. Negative list basically means we have a list, first of all. Those industries that were out of the list were certainly open to foreign investment. Only those industries and sectors that are in the list are either prohibitive or restrictive to foreign investment. So this is not only a gesture to open its economy, but also, a giant step. Why did I say? Because the negative list at the very beginning was supposed to be narrowed from time to time. Due to this change, the MPC finally found this test seemed to be quite successful, or this pilot process seemed to be quite successful. The MPC amended 3 laws, as we already said, 3 laws on foreign investment in the year 2016, so that the case-by-case screening system was replaced by a negative list approach nationwide. So after 3 years of tests, the system has been applied nationwide. But still, there were needs for a unified foreign investment law. As we said, the law was fragmented. And sometimes you can find overlapping, sometimes you can find contradictions among the laws, regulations, and ministerial rules. So there was a need to unify the foreign investment law, not only due to the high demand from the foreign investor, they need more transparency for foreign investment laws and regulations. And they also need further liberalization, which were more or less prompted by the international investment rules, including bilateral investment agreements and free trade agreements with investment chapters. So they were demanding further liberalization, facilitation, and of course, strong protection for foreign investment. That's an internal response to external factors. So internally, there was also a need of the government for better management of investment. You can imagine, because generally they have to liberalize the foreign investment, but on the other hand, they need to exercise certain control over foreign investment. So this is what's called management of foreign investment. So because of this, a new law was being in the process of deliberation. You possibly have already known. It was the MOFCOM, that is the Ministry of Commerce. First drafted foreign investment. It's called 外国投资法 in 2015. Apparently, in the effort to compete for the domestic influence in this area, the NDRC, that is the National Development Reform Commission, also started drafting a 外商投资法 in 2017. So we found there was more or less a dialogue between the 2 versions. But at the end of the day, it was the NDRC version that prevailed. Why? That's an interesting phenomenon. If you are interested, I can tell you later. But nevertheless, it was Xi Jinping's speech in 2017 in the so-called meeting, conference of Sengaizu, which associated further opening up with the unified foreign investment law that gave rise to the legislation of this law. Just a couple of months later, this law came into effect. And as I already said, this law was attracted wide attention and came into effect very soon. I should say came into existence very soon. Why? Maybe many people will try to associate with the adoption of this law with the trade war. Of course, I personally believe it might be a factor. But on the other hand, I think this country has realized that opening up actually must be continued. Opening up policy must be continued. Sorry. Yeah, should be there. This law, as we said, was adopted in 2019, and it was supposed to further expand opening up. And its main focus is about the promotion of foreign investment law and the protection for investment law, and of course, standardized foreign investment management. So the main contents are always related to the promotion of foreign investment and and protection for investment and management for investment. And as I said, the trade war, unprecedented trade war between the US and China was a catalyst. But I have to say, the predominant driving force behind the law was still the domestic need to promote further reform laws, further opening, but frankly, there must be such a mentality to convey a message of affirmative attitude towards the further opening, and of course, to appease the United States in a certain way, particularly when it comes to the trade war. You certainly know one of the main concerns of the US during the trade war was the so-called inadequate protection of intellectual property and forced technology transfer. And actually, these two concerns were also addressed by the foreign investment later. So that was very interesting, actually. But nevertheless, it was to convey a message of further opening up and to encouraging foreign investment. The core system of this law certainly was what we already have been borne in mind, that is a national treatment plus a negative list for foreign investment. The law, if you quick look, the law consists of 6 chapters. Promotion investment, protection investment, managing investment are the main content for, of course, yeah. When it comes to foreign investment promotion, we find quite a lot of articles were dedicated to this. I don't know, because I do not have too much time, so I will skip quite a lot of them. I will focus on the highlights of the law. Professor Zhu told me I have only something like 1 hour, so I think I have to skip most of them. If you are interested in, certainly I can share the slides with you. Yeah? I prepared quite a lot, actually, unfortunately. The only thing that you are supposed to know is that the law focuses on promotion for investment. Maybe I can highlight some. Yeah. Just like every law, if we say foreign investment law is an administrative law, I do not think you will have a different opinion. So, like any administrative law, this law, the main purpose is to set forth rights of foreign investors. And occasionally, it also set forth obligation for investor. But you will have fun when it comes to setting of rights for foreign investor. This law spare actually whatever it takes to specify the rights. When it comes to the obligation for investors, actually, it basically uses a very general term. Very general term. That's very interesting. Just a quick look. Article 4 certainly is an article that set forth the dominant rights or the most important right that foreign investors are entitled to. National treatment. Article 9 also said shall equally apply all policy of state to support. So you will find Article 9 to Article 9 and quite a number of articles, Article 14 as well. Article 14 is now. Article 17 and quite a number of articles actually are primarily an elaboration of what national treatment that foreign investors are entitled to. It basically gave a very complex, in a detailed way, a list of the rights that foreign investors are entitled to. While it comes to the obligations, you will find they are basically very, very broad. Sorry for this. So I feel a little bit awkward because I just do not have so much time. I'm not given so much time. You see, it said foreign investor and foreign enterprises shall abide by Chinese law. That doesn't mean anything, because every foreigner is supposed to abide by the laws of the whole state. Article 18, it also says areas where investment prohibited stipulated in the Act of Nations for foreign investors may not invest. That's basically an explanation of negative list. Again, Article 30, it says, when foreign investors invest in industry and in fields where licenses are required in accordance with, that's a common sense. If you want to go into an area that licensing is required, certainly you need to apply for a licensing. But that's a common sense. But these actually, you will find that conveyed a very nuanced message that this country is really serious towards the rights for foreign investors. While it comes to obligation for investors, this law was basically repeated what has been written into other laws. So that's a very funny phenomenon that you might pay attention to. Maybe I can. It's also in parallel with setting for the rights of foreign investors. It also specifically laid out the obligation of government. For example, this Article 16, apparently is related to national treatment, but it specifically said the state must guarantee the foreign invested enterprises participate in government procurement activities through fair competition in accordance with the law. So they are in the same position as domestic enterprises when it comes to the possibility of attending the government procurement market. So it does not spare any, I should say, it does not, it's really, I should say, meticulous in specifying the obligation of the government. It also says the government shows simplify procedures, improve efficiency, and optimize government services. You possibly have already known this country has already a very comprehensive system for provision services to foreign investors. And this law further specifies the obligation in the unbelievable detailed manner. Relevant competent departments shall compile and publish foreign investment guidelines to provide services and the convenience of foreign investors, and so on and so forth. Yeah? You will find, so I do believe the law was sincere in spelling out the rights, and while it mostly repeated what had already been written concerning the obligation of foreign investors. Yeah. Of course, when it comes to the management of foreign investment, we also should know there are at least two provisions that might be very seriously written into the law. First of all, it's a so-called foreign investment information reporting. This apparently was spelled out in order to balance the general liberalization of foreign investment. Foreign investor must report, even though previously, because the government had the power to screen investment on a case-by-case basis, so no reporting was required. At this moment, no screening was required, so government tried to have a certain leverage as regard to management of foreign investment. And again, as already said, the state protects intellectual property rights of foreign investors. And this, of course, has been written into all the intellectual property rights law in this country. But again, it mentions this just in order to appease the concern of the US during the trade war, as we've already highlighted. But in this regard, we can find it clearly announced the government will not conducting so-called forced technology transfer. And in this regard, possibly I should also mention, almost at the same time when this law was adopted, the Chinese authority, the State Council, repealed certain provisions in the so-called regulation on technology imports and exports, which were the primary source of so-called forced technology transfer. Because of time limitation, I certainly will not go into the details. One thing I also mentioned when it comes to foreign investment management, that is, it clearly states the state shall establish a so-called foreign investment security review system, national security review for foreign investment. And even though this system had been there, even started from something like 2011, but this law certainly tried to incorporate this again, because and only because this was treated as a leverage that the state can prevent a certain unwanted investment, in addition to the negative risk. And you possibly have already known, not long after the law was adopted, and the Ministry of Commerce and the NDRC adopted a measure for foreign investment national security review. And another point I think I need to say about the obligation of the government is that it was, from my point of observation, it was the very first time that governments were imposed such an obligation to keep confidential about all the information that they have access to regarding the foreign investor enterprises. This was the very first time the government will impose such an obligation to keep confidential to all the trade secrets, known in the process of performing their duties. So they will be held liable if they disclose such information to outsider, to Chinese enterprises or whatever. And they might even be held criminally liable, liable under the criminal law. And when it comes to the obligation of the government, we also found the local governments actually the readiness to resort to competition of incentive competition actually is more or less subdued, because they are no longer in a position to spell out as preferential policies in a certain way. Just because of time limitation, but I think I need to speak most of them. Indeed, it's very unfortunate, but if you have any question, we certainly can discuss later. Features of the law and its relevance to the business environment in the country. The law is designed to meet the needs of foreign investment liberalization in the context of market-oriented economy with Chinese characteristics. The law empowered the Chinese government to continue to foster and develop the more open and transparent foreign investment environment. It intends. The law established the right of foreign investment enterprises to participate in market competition on equal footing in various ways, including, let's say, the government procurement in terms of financing themselves in terms of all the rights, all the facilities that may be available to domestic enterprises. The law clearly established the government's obligation to serve foreign investment enterprises. And in anticipation of the more emerging investor-state disputes, the law even provides foreign investor with a special system which is similar to the ombudsman system in Nordic country, which is called a foreign investment enterprise complaints mechanism. You certainly know when a foreign investment enterprises had a dispute with the government, it certainly can resort to the so-called administrative litigation as well as administrative reconsideration process. But now a new process was added, which was made only available to foreign investment enterprises. Even though this is not purely a formalized dispute settlement mechanism, but it could be used by foreign investors, thus limiting the possibility of the occurrence of a true or genuine legal dispute between foreign investors and the state. The law also specifies the authority of local governments in formulating relevant rules to avoid bad competition for foreign investments, incentive competitions. And the law also established, at least in the area of the rule of law, established the rule of law at least relating to transparency. I should say the law at least established the rule of law relating to transparency. A unified law, of course, is itself per se is an example. And more or less, it specifies what kind of measures the state shall adopt. But you can find, unlike the previous three laws, which formed the foreign investment regime in the past, this law did not encourage ministries to adopt their rules. So normally it said only the state council can provide it this way or that way in terms of, let's say, incentive provision, incentive preferential policies, in the name of administrative regulation or in the name of notices, orders. That's all, yeah. So the foreign investment at least can be said to be leading in the construction and the consummation of the business environment. It took the lead in the nationwide effort to build a prime business environment. It took the lead. That's what I like to say. But having said that, I must remind you the limited role of this law, particularly where we are in such a context of a wave of foreign investment exit. Recent years, indeed, we have seen a wave of foreign investment withdrawal exit from China, which certainly has attracted wide attention. I'll just give a couple of cases. Samsung, which certainly was once a dominant player in the Chinese market, closed its mobile phone factories. Basically, it has completely withdrawn from the mobile phone manufacturing in China. Oracle, in 2019, Oracle laid off all workers amid the efforts, the so-called DIOE policy. I don't know whether it's a policy, but there was a sentiment, DIOE, and then left. Oracle left. Citrix again left because of cost reason. And more alarming, the case is IBM, because IBM entered the Chinese market. It was one of the earliest of American foreign companies that entered the Chinese market. IBM left today, just a couple of months ago, 2 months ago. Its employees, of course, I'm talking about its R&D facility, which was often regarded as the bone, as the core of foreign investment, foreign presence, commercial presence in China. It left. We don't know, because we do not have an accurate statistics figure as far as the trend is concerned. If we were to project the trend, possibly we are not in such a position because we do not have an accurate statistics figure. Nevertheless, there are some relevant information which might suggest the trend. in 2023, for example, information shows that in the first 3 quarters, foreign investment growth exceeded something like 10 billion US dollars. Just remember the total annual investment influx into China was something like 100 billion in the so-called the high day years. Yeah, I mean those days. But now basically 10% of the foreign investment has left only for a couple of months. And data from the Statistics Bureau also showed the amount of foreign investment utilized nationwide exhibited basically 10% of decrease on a year-on-year basis. Again, we found in this year, in September, in the second quarter of that year, reportedly in September, there was a report in the second quarter of the year about basically 15 billion US dollars of foreign investment was withdrawn, marking a record high exit foreign investment in the same period. And as of September 30, 2024, in the third quarter of that year, in this year, the amount of Chinese enterprise stocks sold by foreign investors through the Shanghai Hong Kong Stock Connect was as high as 80 billion US dollars, equivalent to about 10 billion US dollars. So this trend seems to be continuing. Huh? We never know where it will stop. Reasons. Before we try to establish a correlation between the foreign investment role and the foreign investment law and foreign investment exit, we need to find the reasons. I think there are a couple of reasons. First is market-related factors, such as changes of cost. Labor cost is certainly rising. Market competition also matters, like traditional vehicles and now the e-vehicles, electronic vehicles. That is a competition pattern. And a trend in consumer demand, more or less like this. And even concern about technology leakage or effective protection of intellectual property rights, concern for this, particularly in the high-tech based competition. These are the so-called market-related factors. Take an example. The rapid development of Chinese domestic enterprises has intensified market competition. Domestic manufacturers in such industries as electronics, automobiles, and consumer goods have made great progress, gradually eroding the market share for U.S. enterprises. In the mobile phone market, as well in the car manufacturing industry, and the foreign investors really face harsh competition from rising Chinese factories and Chinese companies. So certainly no, these are the market-oriented reasons, that's understandable. But another alarming factors are non-market related factors, because that basically are concerned with uncertain geographical, geopolitical factors and even domestic reshuffle. Geographical tensions, as we have already been witnessing, and the trade frictions between countries, between China and the rest of the world, have a huge impact. Some foreign investors certainly are facing uncertainties and the challenges due to the change in the international political and economic environment. Trade barriers, so many trade barriers. In the EU market, for example, they launched so-called anti-subsidy investigation against Chinese e-vehicles. So was the case in the US. And the sanctions, of course, US imposed unprecedented range of sanctions against Chinese products, particularly in the name of so-called national security. And the US are also sparing no efforts to rearrange global supply chain. They are repositioning global supply chains, which certainly affect the decisions of businesses for investors. Sometimes we can also find the two factors are co-intertwined, are correlated. For example, if a big factory had to leave because of the concern that the national security, whatever, the so-called the component supply may also follow suit. That's honestly because the later certainly is a market consideration, but the primary reason is still driven by the geopolitical concerns. In this regard, possibly I can just mention an example. Do you think if there is a possibility that the chips company of the US are going to continue their business in the Chinese market? Possibly not. They are either relocating for the purpose of acquiring subsidies from the US side, also relocating because of they are unsure of the market certainty. Predictability is always a major concern of foreign investors. The geopolitical factor that contributed to uncertainty and unpredictability. And possibly most, I wouldn't say most, at least as important as important as geopolitical situation, domestic reshuffling possibly is another factor that contributed to the uncertainty. Mixed with the opening up tone, there has emerged in recent years from time to time hostile attitudes towards non-state business entities for whatever reason. And there is also an emerging nationalism against foreign capital. And we sometimes even find local authorities even take measure to prosecute against certain foreigners on the national security ground. And we also find there is emergence of leftist ideological return. Of course, because of the sensitivity, I will not go into very detail there. But certainly you can imagine there must be certain factors that might give rise to worries on the side of the foreign investor. Domestic reshuffling, I personally believe, is one of the most important factors that may affect foreign investment decisions. Uncertain geopolitical factors, domestic reshuffling, lead to a transition from market-oriented business environment to national security-centered business environment at home and abroad. So traditionally, the market-oriented the business environment seemed to be substituted or replaced by a national security-centered business environment at home and abroad. Possibly you have already heard a typical Chinese term, 统筹安全和发展. Literally means security should put first and development possibly shall be given a little bit. I don't know. We imagine this is not accurate interpretation. But my understanding is that national security-centered business environment is emerging, of course, not only in China, but also in the US and in many other countries. Such adverse externalities in connection with the national security-centered business environment often give rise to strategic adjustment on the part of multinational companies or foreign investors. Some foreign investors are affected by uncertain geopolitical factors, and they might adjust their global business strategies, which lead to the withdrawal, the reduction, and the exit of foreign investment in China. Overall, foreign investment withdrawal or exit from China is a complex phenomenon influenced by multiple factors. In the face of adverse externalities that drive the wave of foreign investment exit, I think we can see the foreign investment law has its own limits. Possibly, you possibly have still remember that I said in the past, the foreign investment regime was generally investment favorable. Somebody might also challenge this because possibly it was a market potential. It was the low labor cost that drove so much foreign investment flew into China. So at this moment, possibly we shall now expect too much the foreign investment to play a very positive role to reverse the trend of foreign investment retreat. That possibly is my major point that I would like to say. But nevertheless, as a lawyer, you are also trained. We are lawyers by training. So what can be done to this law, and the legal environment in general in the time of uncertainty? Despite the limited role of the law, China is still improving its business environment, as we have already said. From the legal researcher, from law researcher and the legal practitioners, as far as the foreign investment law aim at improving the business environment, fail to attract foreign investment, and even cannot retain existing foreign investment, it's imperative to study whether they are deficiency in the current law. This is something that we can do. I have personally conducted a research immediately after the foreign investment law was adopted. Possibly I should also introduce a little bit. I was heavily involved in drafting the foreign investment law, which was proposed by the NDRC. I prepared initial draft, which was supported by the World Bank. And I immediately after the law was adopted, I was retained by the MPC, a commission of the MPC, legal commission, and to conduct a research on the implementation of the foreign investment law. And later, 2 years later, I was also retained by the Beijing People's Congress to conduct, to draft a so-called local regulation of foreign investment. And during these days, we conducted research. The research is to find if there is any deficiency in institutionally or at the level of implementation. We do find certain institutional defects and do find certain ineffective problems in ineffective implementation of the law. The former includes potential conflicts between verification and recordation system for the foreign investment project. I don't know whether you know this verification and recordation system. That was the legacy of the so-called planned economy. All the projects, 项目, must be verified or at least recorded by the authority, by the NDRC or the local counterparts. This actually, to some extent, offset the role of negative list, national treatment plus negative list, which was enshrined in the foreign investment law. And there's other room to improve regarding security review system. We certainly know currently there's no clear definition of foreign national security. So there is a substantial discretion on the government side. And also, we do not know how exactly the national security review system interact with the so-called anti-monopoly review. As a particular foreign investment and to review my ensue, we don't know exactly. Of course, from the perspective of from the government's point of view, they have the discretion, they have the freedom to prevent unwanted investment in the form of this way or that way. But when it comes to foreign investment, So they might feel a little bit confused how these systems interact with each other. And also we found there's a policy transparency requirement. Policy transparency requirements are not fully conveyed. Still, certain provisions, particularly concerning how to conduct the businesses on the part of the government, are not yet known. And another fact that is related to another law, that the anti-foreign sanction law, might also have a side effect on foreign investment. Why? Anti-foreign sanction laws basically require at least foreign enterprises in China must comply with all the requirements in this regard. Let's say if a U.S. company is situated in China, U.S. government says you need to stop selling certain chips, let's say, just to simplify it, right? Selling certain chips to a Chinese company, let's say Huawei. If this company had already agreement with Huawei, in accordance with the order from the U.S., it stopped delivering the goods to the Huawei. Certainly, this will be illegal under the anti-foreign sanction laws. So the foreign investor will be in awkward position. So I think this will also have a side effect. Of course, the anti-foreign sanction laws was adopted later. It was not adopted at the same time with foreign investment. So we find there are indeed certain problems, institutional problems regarding designing. We also find a problem regarding implementation. I will stop with half a minute possibly. I want to say certain, despite that the law has adopted quite a number of requirements by governments at various levels, certainly are not always comply with the requirements, the law requirements. For example, there's a lack of unified platform to provide policy consulting services. Many governments, within their own competences, they will offer their own advices. But possibly there's a contradicted considered advices which are adopted by various authorities. And there's no official interpretation of relevant policies, official interpretations. Particularly certain rules are not necessarily detailed enough, but they need interpretation, but we do not have official interpretations of relevant policy. All these suggest there is a direction, suggest the future direction for a better foreign investment regime at such a moment of uncertainty. Even though we cannot do much, but we still can do something in terms of institution perfecting. Thank you very much. Because of time limitation, I skipped most of them, unfortunately. 你也可以用中文玩 if you like.
Thanks for Professor Kong's very informative sharing. I do have two questions for you because I read most of your article before and cite them, and I also heard one of your lecture organized by Fudan University, which you introduced your research about the enforcement of foreign investment law. And I'm very surprised that HKU invite you to get this speech and sends professor to organize this. And my question is, the first question related to the compare mechanism that based on your empirical research or other work. Do you think the compare mechanism that introducing foreign investment law really operates in that to resolve this kind of foreign investment related disputes? Because the exit report as well as other kinds of international report, they pose the concerns about the uncertainty about how the new complaint mechanism that really resolve this kind of foreign-related dispute, because there are certain uncertainty and ambiguity about legislation about how this mechanism really operates in practice. And the second reason is that do you think the bilateral investment treaties, some standard in it, really internalized in foreign investment law in China? Because I saw some standards like national treatments, they really internalized in the new foreign-related rule of law. So to some extent, is it okay to say that some standards in bilateral investment treaty they do internalize in the domestic law in China to enhance the rule of law in China to protect foreign investment domestically? Thank you.
Thank you so much. Thank you so much. I understand the fourth question is about the special mechanism or complaints mechanism for foreign investment enterprises. Yeah. Actually, this is informal mechanism. It's not intended to be a real dispute settlement process. So basically, either both the foreign investor and the government, the competent government authority are in tremendous discretion. They can negotiate, they can always complain, they can always, at whatever process, reach an agreement and a non-necessary agreement or provide certain advices, as long as the two parties are, at least the foreign investors, from foreign investor point of view, it's capable, the certain proposal is acceptable. With such a process, at least the true dispute, the genuine dispute will be retarded. The occurrence of genuine dispute will be retarded. Again, you need to know, even though this mechanism cannot solve a true dispute, cannot solve a dispute, and the foreign investor, particular foreign investor enterprise, can still resort to the administrative reconsideration as well as administrative litigation process. So their rights are not deprived, even though they have already resorted to the so-called dispute settlement mechanism. So I do think this will be a plus, not a negative part, as far as the whole foreign investment regime is concerned. That's my understanding. So at least we can prohibit with this system, with this mechanism in place, less disputes would occur as you know, in the situation without such a mechanism. So I think it's a plus, it's positive. And the other question is whether those provisions in the investment agreement, bilateral investment agreement, have been internalized. Actually, first of all, I would like to refer you to Article 4 of this law. This law basically says if there is a better treatment under the international investment agreement, and this investment agreement will prevail. Funny enough, so even without internalization process, the international investment agreement, which provide a better treatment of foreign investors, will also be applied by the authority. Of course, indeed, every treaty, including international investment agreements, has had to undergo a process of internalization by adoption, by incorporation, or by adoption a new law, where the legislator take into full account the requirement of the international investment agreement. But even without such a process, Article 4 still provides that international investment agreements which provide a better treatment for foreign investors shall be abided by the authorities. So this is what I would like to say to your question. Thank you very much. Yeah, you apparently have studied quite well about foreign investment. Thanks a lot. Yeah.
Thank you very much for your presentation.
Yeah.
So I have wondering if you could talk a bit more about Article 20,
Article 20.
foreign investment law, and the reason why is because from the foreign investor's perspective, I would read that and say maybe China doesn't mean what it's saying in this law, because
Protection of foreign investment.
expropriation is actually not prohibited, right? The requirement under international law is you have to compensate. But states are allowed to expropriate. But this language says no expropriation. This is a huge development in international law. If I was an investor, I would say, okay, well, this would taint the whole foreign investment law because it feels like it certainly can't be intended. It can't be accurate.
Yeah, Article 20, as you said, basically about protection of foreign investment from expropriation and possibly indirect expropriation. But you will find from the text of this Article 20, it basically says the government shall, in normal situations, not expropriate any foreign investment. In exceptional cases, where public interest is involved, where compensation is to be provided, where due process, even though we do not use the word due process is provided, such expropriation can be legalized. But if you compare Article 20 with the so-called implementing regulation of the foreign investment law, and that regulation provided detailed way how to offer remedy, how offer reasonable compensation. The compensation is, based on my understanding, is almost similar or equivalent to the so-called adequate, prompt, and effective compensation, which is so-called Howe principle, Howe doctrine. You need to combine Article 20 of the law as well as the relevant implementing regulation, the article in the implementing regulation, and which specified a better or transparent or at least clear definition of compensation. So far, you possibly have already found there are so many cases that have been have been brought to international arbitration against the Chinese government, and so far you'll find not single. I wouldn't say not a single case, but at least very few cases. The foreign investors have won very few cases even in the field of expropriation. That possibly is also an evidence that this country actually possibly is serious concerning Article 20. I wouldn't say there is a discrepancy in letter and in practice. Of course, maybe different people can have different observations. You must have paid attention to the so-called Heidelberg case. The German company in Qingjiang province, Qingjiang, Shandong province, it was brought to the international arbitration, even though we haven't seen the final result. But it seems that the case a award has been rendered, if I remember correctly, and that's the final award. I think was in favor of the government's exercising of the so-called zoning laws, and it was not regarded as expropriation, even indirect expropriation. That's my understanding. So my understanding that you need to also take the implementing regulation into consideration when you are making a comment on the foreign investment law itself. That's my suggestion. Thank you.
I think restriction on financial industry enacted this
Financial industry
since 2020, I guess. And at the same time, I think China's government show a strong attitude towards financial security. Like, for example, some regulation of financial security can sometimes be recognized as law if the contract is invalid. So my question is, if this foreign investment law is kind of like complex of financial security. You can actually hear more about this.
Actually, this law, I do not think this law is in contradiction with the recent measures concerning opening up of financial industries, because this law itself, it only adopted so-called national treatment plus negative list. But as to what industry is open to foreign investment, you need to look up into the so-called negative list for cross-border services, trade services, or services trade, negative list for cross-border services trade. And you will find certain industry, if the industry is not listed in the negative list, then certainly the industry is open. But when it comes to financial industry, we certainly know almost every international investment agreement, no matter whether it's a bilateral investment agreement or regional trade agreement, there is so-called financial carve-out or financial prudentiality exceptions. So these exceptions certainly can be used by the whole state to accept certain financial service provider. On the other hand, financial security, national security exception is also commonplace for every international investment agreement. Of course, it has not been settled to what extent financial security can be regarded as a problem which is embodied in the national security exception. But possibly, if there is a need, the authority might also take advantage of the so-called national security exception to prevent a certain financial provider from entering the market. But at least at the moment, we do not have a single case, empirical evidence. But financial carved out or financial prudentiality, that actually can already be used by the authority. Yeah.
So please join me to press a poll.
Thank you so much.